morning.
Good morning, honorable members of the committee. My name is Deborah Misir. I'm an attorney residing and practicing law here in Nassau County. I previously served as an attorney in the White House Counsel's Office and the U.S. Department of Justice.
Would you move in a little bit toward the microphone?
Yep.
There you go.
I'm here as president of the Indian American Bar Association of Long Island and Queens. I also serve on the board of advisors of the Irish American Bar Association. My testimony today reflects solely my legal opinion. First, I'd like to thank the task force for holding this public hearing in Long Island and for your commitment to listening to as many different voices in this great diverse state of ours. I'd like to focus on two issues of concern to the committee. First, whether the proposed redistricting commission can be created without amendment to the New York State Constitution. My review of the New York State Constitution and applicable precedent shows that the commission cannot be created without amendment to the New York State Constitution. Second issue I'd like to focus on is whether the size of the New York State Senate should be expanded to 63 members from the current 62. From a public policy and good government perspective, I suggest that increasing the size of the Senate to 63 would prevent dilution of each New York citizen's vote and stop the legislative deadlock that unfortunately we've experienced in the last few sessions. One reason I'm here today is I've read in the media that state legislators in this task force have received some criticism for not supporting the establishment of a so-called independent commission. I don't think this criticism is fair because, as I mentioned, I believe you need to have a New York State amendment. You need to have an amendment to the New York State Constitution. Under the New York State Constitution, the state legislature is vested and only vested with the power to readjust and reapportion Senate and Assembly districts. No other branch of government is given that power. The state legislature, as a matter of law, cannot simply forego or delegate its constitutional responsibility. Moreover, it's questionable whether a redistricting commission could be created for a period extending beyond the existing legislative session. Finally, I would suggest the state legislature cannot bind its future actions through the creation of such an independent commission. An amendment, on the other hand, would be a legitimate method of establishing an independent commission. It would have the power to provide for the commission's powers, authorization, and funding. And they would also be able to lay out what role the commission would play in any inevitable litigation over the proposals the commission came up with. I would also note, just as a legal matter, that if there is an amendment to the New York State Constitution considered, we should also look at other provisions that need to be upgraded in our voting scheme. As currently written, certain apportionment provisions do not appear to pass muster with the Equal Protection Clause of the U.S. Constitution. And here I'm referring to that old case in 1964, the Lomenzo case. Now, the New York State Constitutional Convention of 1967 proposed certain amendments to the New York State Constitution to meet the concerns of the U.S. Supreme Court in Lomenzo, but the proposals were rejected by the voters. So the legal issue still remains. So any effort to amend the Constitution and any effort to look at these redistricting provisions should be carefully reviewed in light of that old Lomenzo case. Also, just to echo what has been said earlier, the current proposal for an independent commission does not fairly represent the spectrum of political parties across the state. The proposal would have the commission comprised of 8 appointees, 4 appointed by the governor, 1 by the Senate Majority Leader, 1 by the Senate Minority Leader, 1 by the Assembly Speaker, and 1 by the Assembly Minority Leader. So 6 members would be elected by Democrats, as we are currently constituted, and only 2 by Republicans. This does not strike me as an independent commission. If we had a Republican governor, it would be similarly unfair to Democrats, because it would be skewed towards Republicans. So I believe this proposal runs directly contrary to the spirit and text of the New York State Constitution. which vests the legislative branch, not the executive branch, with the power to reapportion. I do support the legislation passed by the New York State Senate this past March because it was a bit more evenly balanced, with 4 members selected by the legislature, a Democrat and Republican from the Senate and a Democrat and Republican from the Assembly, who would then work together to pick an independent citizen member, similar to the citizen members we have sitting on LAT4 today. This is exactly the kind of bipartisan process we need in New York. However, as you all are more familiar than I am, we're running against the clock at this point. I understand the primaries have been moved to June of 2012. So the state government must complete redistricting in the next 6 months. We simply do not have the time to experiment with a redistricting commission. For that reason, I suggest that the task force itself should conduct redistricting for this election cycle. It is bipartisan and comprised of experienced members who have had the opportunity to listen to the voices of New York State citizens at these hearings. I believe the task force can, at this point, best represent the interests of New Yorkers. And with regard to the second issue I'd like to bring to your attention on the increase of the New York State Senate, I know it's been raised at several previous hearings. I'm here to support the proposal to increase it to 63 for 2 reasons. First, the increase of the size of the Senate would prevent the dilution of each New Yorker's vote. Second, as a practical matter, increasing the size of the Senate to 63 would avoid legislative gridlock. Certain individuals who have testified before this task force in the past have suggested that there is no constitutional basis for creating other than 62 seats in the current redistricting. And respectfully, I'm here to testify that that position is simply not true, and it's ludicrous. Contrary to the plain language of the New York State Constitution, the New York State Constitution initially fixed the number of senators at 50. And here I'm looking at Article 3, Section 2 of the New York State Constitution. However, the New York State Constitution goes on in Section 4 to provide that the state legislature can readjust or alter the number of senators above 50 to ensure the integrity of populous counties and that the residents of those counties are not deprived of representation. And in fact, the New York State Court of Appeals itself, in the case Dowling in 1916, approved increasing the number of state senators. Indeed, this was most recently demonstrated in 2002 when State Law Section 123 increased the size of the Senate from 61 to 62. So there's no question that increasing the size of the Senate to 63 is lawful and permitted. If the task force decides to recommend that, or the Senate or an Assembly decide to proceed along those lines, they would want to be mindful of the requirements of the U.S. Constitution relating to the one person, one vote requirement, and the New York State Constitution, which requires that the integrity of the various counties be preserved when redistricting. With respect to the federal one person, one vote requirement, the U.S. Supreme Court has held that the state legislative plans may not deviate from below 10%, may not deviate above 10%, to be acceptable under the Voting Rights Act and the U.S. Constitution, and that was affirmed in the Rodriguez case in 2004. With regard to the New York State Constitution, the New York Court of Appeals has again said that we have to respect the integrity of the county units. So any redistricting effort has to look at those two competing concerns and come up with the fairest plan. The most important reason to me why we should increase from 62 to 63 is frankly the voter dilution. New York's population has increased over the past 10 years from 18,976,811 persons to 19,378,102 persons. So currently, each of the 62 senators represents approximately 306,077 individuals. So the average number of a person represented by a senator in a 63 setup would be 307,588 people. If we remained at 62, however, they would be representing a larger number of individuals at 312,550 individuals. And of course, we'd be better served having an odd number of senators, so we would not have deadlocked votes in the Senate and stop the conduct of business in Albany. In conclusion, I'd like to also add, as president of the Indian American Bar Association, that there are no Indian Americans in the U.S. State Senate. To my knowledge, none in the New York State Assembly, none on the New York State bench. We make up a considerable portion of the New York State population. We're active, proud Americans. I would urge the committee to consider redistricting so that Indian Americans have an opportunity to have their voices heard in the Senate. And I would urge the task force to do your best to assure that we have competitive districts for the state legislature and congressional seats after redistricting. I think everyone here would agree that our interests are better served when competitive elections are run. Thank you very much for your time and consideration.
Thank you. Senator DeLon.
Yes, thank you for your testimony, and I see that you have done a somewhat thorough job with respect to abiding by the law.
Yes, sir.
And I believe you have cited some cases here for us. My question has to do with the current formula that's in the New York State Constitution. According to information that I have and testimony from previous hearings, many individuals have testified that if we literally interpreted the Constitution of the state of New York and the current formula that's in there, you come up with a number of 62. How do you come up with a number of 63?
Well, you're absolutely right, sir. The formula is indeed very complex. The formula does not specify a specific number. It goes by the census numbers as they're fed into the county numbers.
How do you answer my question as to many have testified that if you apply the formula the way it's written, it equals 62. And if you want to argue for an odd number, you talk about 63.
Yes.
Why not 61? You also talk about dilution of the vote. Maybe you want to explain that a little further, because if you maintain the lowest deviation possible in every single district within the Senate throughout the entire state, then you would be abiding by the one person, one vote principle. So how would you be diluting someone's vote if you made all districts equal in terms of population wherever that is possible?
Well, I hear what you're saying, Senator DeLon, and I actually share your perspective. I think
but my point is here, you're asking us to apply the law everywhere with the exception of a formula that's within the Constitution of the state of New York. Why the exception?
No, that's not true, Senator. That's not true. I'm suggesting that we strictly adhere to the New York State Constitution, and it does not fix the number of state Senate seats at 62. It is a flexible, in their wisdom, the folks who wrote the New York State Constitution understood that the population could grow and increase. They also were very concerned with maintaining the integrity of representation of counties and not breaking up counties. So they provided for an increase of state senators from 50 up to whatever amount the body found to be acceptable. They provided for that in the New York State Constitution itself. Now, I'd be happy to provide you with an analysis of the formula. I'm not prepared to do that right now.
I believe that you indicated previously that, as others have testified, that if you actually follow the formula, you come up with the number 62. Is that correct?
No,
just a few minutes ago.
No, I apologize if I wasn't clear. What I said was others have testified that it has to be 62.
That has to be, that the formula results in 62.
I've seen testimony where folks have said that.
Do you agree with that?
I'm sorry, I didn't catch that question.
Do you agree that if you applied the formula in the Constitution and strictly applied it, that the number would equal 62?
No, absolutely not.
Well, then you'll have to show us
I'd be
how
glad.
it's different.
I would